Hey everyone, so the case I've chosen to discuss today is the Neto versus Klucatch case, which is a judicial review of a decision by the Ontario Consent and Capacity Board concerning whether Miss Neto, a psychiatric patient, had the capacity to make decisions about her own treatment. So the key issue that was presented before the Ontario Superior Court was whether the board had correctly applied the legal standard for capacity under Ontario's Healthcare Consent Act when it determined that Ms. Neto was incapable of consenting to treatment. So I want to first go over a couple background facts that I believe are pertinent to this case. So Ms. Neto was a patient at a psychiatric facility where she was detained involuntarily, and her treating psychiatrist, Dr. Klucatch, proposed a treatment plan for her mental illness, which she had refused. And Dr. Klucatch, because of this, determined that Ms. Neto was not capable of making treatment decisions, and the matter was brought before the review board, which is the Consent and Capacity Board, and this board upheld the psychiatrist's finding and ruled that Ms. Neto lacked the mental capacity to consent to or refuse any treatment, especially because she did not accept that she had a mental illness. Ms. Neto then appealed this decision to the Ontario Superior Court of Justice, which is the case we're going to be focusing on. So this case raises issues related to patient rights, involuntary psychiatric treatment, and administrative decision-making. The central issue I want to talk to about today is how the legal test for treatment capacity was applied. So the aspect of the case I'll be focusing on in this video is going to be the Healthcare Consent Act, the HCCA, as I already stated before. So for some background on the legal aspect of all this, under Section 4 of the Healthcare Consent Act, a person is capable of consenting to treatment if they, 1, understand the relevant information about the treatment decision, and 2, they can appreciate the reasonably foreseeable consequences of making or not making that decision as well. So a key issue in this case was basically whether a person must acknowledge or accept their diagnosis in order to be considered capable. The board concluded that because Ms. Neto couldn't accept that she was mentally ill, she would not be able to appreciate the need for treatment, and therefore was deemed incapable. However, as I just talked about the Healthcare Consent Act, this law does not require acceptance of one's illness as a condition of capacity at all. What matters under this law is whether the person can understand the facts presented to them and also understand what might happen if they accept or refuse the treatment. So the Ontario Superior Court actually ended up granting Ms. Neto's appeal because they found that the board improperly relied on Ms. Neto's refusal to accept her diagnosis as evidence of incapacity. But like I just stated, under the Healthcare Consent Act, this is not one of the conditions to be deemed as incapable or capable. And since the board failed to apply this two-part legal test appropriately, their reasoning blurred the line between clinical judgment, aka like their personal opinion, and proper legal analysis. So the court ended up overturning the board's finding and declared Ms. Neto capable of making her own treatment decision. The second part of this assignment is about breaking down the real-life impact of the case. I want to try and explain what this case means for individuals within the healthcare system in a way that balances the legal jargon with a simpler language explanation. So this case is about protecting a person's right to make their own decisions about their health, even if those decisions may seem questionable or go against medical advice. This case reaffirms the fact that every individual has the legal right to decide whether or not to accept any medical treatment or medication, as long as they meet the standard of capacity set out by the Healthcare Consent Act, because capacity isn't dependent on whether someone agrees with their diagnosis or follows their own doctor's recommendation, and it's not based on a doctor's personal opinion. So if I were to explain this to a family friend or a family member, I'd put it like this. Even if a doctor or psychiatrist thinks you're making a bad decision, such as refusing treatment, they can't override your choice in any way unless they can show you're legally incapable. That means you don't have to agree with the doctor or even believe you're sick, as long as you understand what's going on and what can happen if you refuse. This case protects your right to control your own body and your own medical decisions. This Neto versus Klucatch case has even been cited in other cases, and an example is the RJ versus Zaland case in 2016, where the court referenced Neto versus Klucatch to state that a patient's mental condition doesn't automatically prevent their capacity to make decisions about medical treatment. So the main things to take away from this case would be that disagreeing with the diagnosis doesn't equate to incapacity. And the Consent and Capacity Board, as well as any other levels of government, must apply this law as well, instead of just using their clinical judgment. So to summarize, this case is a reminder that having a mental illness or medical condition doesn't mean losing your voice in your healthcare decisions. As long as a person understands and appreciates the consequences of their choices, they'll always have the right to decide, even if that means saying no to treatment. The case helps ensure that legal standards, not just medical opinions, guide decisions about a person's capacity, making the system more fair and respectful of individual rights. So the final part of this assignment zooms out from the individual to look at how the healthcare system as a whole is affected by the Neto versus Klukac case. This case is more than just a patient's rights case. It has many significant implications for how the healthcare system functions, especially in areas like mental health, administrative oversight, provider regulation, and even public trust in health institutions. So I wanted to look at this socially and politically, where this case represents a shift towards a more patient-centered approach to mental health care in Canada. This method makes sure that individuals, even those with serious psychiatric diagnoses, have the legal right to make decisions about their own treatment, reinforcing the principle that autonomy does not disappear in the face of mental illness. And I think this is a very important point. And politically, this case might also contribute to ongoing debates and many policy-making decisions about the power imbalance between patients and medical institutions, particularly in psychiatric contexts where coercion has historically been more common. It challenges policymakers and healthcare institutions to rethink the role of consent and capacity laws not just as procedural checkboxes, but also as tools to protect individual dignity and autonomy. So in summary, this case basically forces the healthcare system to confront a central question, which is, how do we ensure safety and care without undermining autonomy and legal rights? It doesn't offer easy answers, but it definitely raises the bar for how decisions around consent, capacity, and treatments are made, with ripple effects on training, policy, and legal oversight in major healthcare institutions. Thank you guys so much for watching and listening to my presentation, and I have added the links down below in the description box, which are the links to both the cases that I referenced in my presentation, and I hope you enjoyed.